during this video, I'm going to challenge you to think a little bit further and to not just think about the creative process of being an author, but to think about the legal side of things as well. Because protecting your work is just as important as creating it. Hi everyone, my name is Charisma Antoinette, your new favorite children's book author and librarian. And something I learned very early on as an author is that there's a lot of legal terms that you need to know about. And I learned this through having conversations with lawyers when it came to my book process, not because I was doing anything illegal, but because there were things I was hearing as I was on different Facebook groups or YouTube videos or different conversations I was having with my writing colleagues that made me think, do I need a lawyer? Do I need legal representation here? So through those conversations with those lawyers, I was able to understand some key things that a lot of authors don't know about until it's too late. So in this video, we're breaking down 3 legal concepts that every author, whether you're self-publishing or not, needs to know about just so that you can make sure that you are actually safe and your work is protected. I am not a lawyer. I am an author, I am a librarian, I am an author coach, but one thing I am not is a lawyer. So none of this is legal advice. These are things that I have heard from my conversations with lawyers and things that I have seen come up for other authors in the world. So being mindful of these things are very important, but I cannot stress enough, this is not legal advice. Now, with all that being said, let's dive into it. Number 1, you need a work for hire agreement. Now, I didn't know what a work for hire agreement was until I met with a lawyer, but here is essentially what it is so that way you can understand it. A work for hire agreement is basically a legal document that states that you are contracting someone to do a piece of work for you. And in return, not only are they giving you the work, but they're giving you the rights to own that work. Now, you might be thinking to yourself, if I'm paying someone to do the work, then aren't I already owning that work? And the answer to that is no. You are not in ownership of that work. So when we talk about work for hire agreements, I want you to think about this in a concept of picture books, for example. When I, as a picture book author, pay an illustrator to do the images for my book, I hope you're hearing how I'm emphasizing like the pronouns here. But if I pay them to do the illustrations for my book, they do it, send it to me, I pay them, they go about their day, I have the illustrations, I do my book, I'm living a grand life. Technically, in the eyes of the legal system, though, they own the rights to those illustrations, even though I paid them for it, unless there's a work for hire agreement there, because they haven't surrendered their rights to it. And because they haven't surrendered their rights to it, they still have the ownership of those illustrations. This doesn't matter at first, right? When you're thinking about how you want to do your book and just get it out into the world. But thinking long-term with your books, say you wanted to make merchandise with your book. Technically, the illustrator owns the rights to those images, and that could affect your ability to do merchandise depending on what your relationship is like. And also, technically, your illustrator has the rights to those images so they can resell them to someone else. Like your image of your main character is not uniquely yours to own. It's theirs to repurpose and reshare. So those are important things to keep in mind. Even thinking about it in the terms of doing book covers and different things like that. Whatever someone else creates, they own it unless there is a documentation there that says, I am surrendering the rights to that for you. I don't know if you've done like a photo shoot before recently, but sometimes photographers have contracts where they state like, oh, I'm going to use these photos that I took on my website for marketing for my own purposes, whether you like that or not. They have the right to do that because they took the photo. The photo may be of you, but they own that photo so they can use it however they want to. That's why you may find yourself on your photographer's website, even if you don't really want to be there, but they own the right to that photo. And that's something that you have to keep in mind. If you don't have a work for hire agreement, situations like that can happen like with a photographer, where they can take something that was yours that you did together, but use it for their own ways that you may not be in agreement with. So having a work for hire agreement is one of the overlooked agreements that you can have just to make sure that your work is not only done well, but it's something that you own to protect how it's being used in the world. So when you think about work for hire agreements, think about them like this. Just because you pay for it doesn't mean that you own the rights to it, unless you have your work for hire agreement. Now, keeping in line with the word of ownership throughout this whole video, when it comes to legal terms you need to know, let's go into number 2, which is that a trademark is not the same thing as copyright. Now, this is something that I've encountered a lot as I coach different authors to bring their books from their heads to the pens to the bookshelf. where they think they need a trademark for their book, when in reality, that's not how this works. But trademark and copyright, like they are buzzwords that we hear a lot when it comes to protecting intellectual property, but they're not interchangeable, but a lot of people use them interchangeably. Copyright is a protection of your creative works, whereas a trademark is a protection of your brand. And this is where that difference comes into play because a lot of people feel like their books are their brand because I'm using my books, for example, to further enhance my brand as, say, like a social worker or as an educator or as a subject matter expert about bugs or whatever it may be. But they work in two different ways to accomplish those goals. So when you think of copyright, C, creative works. Keep those two things in mind. C, copyright, creative works. Copyright is only for the written stuff that you have done. Whereas a trademark is more so about, again, protecting that brand. And so when you see a trademark, you're thinking about the little TM that you see, but think about where you see that little TM. You see the little TM on logos or brand identifiers. And so a lot of people I see think that, oh, I can trademark my book, or I can at least trademark the title of my book, for example, or the title of my book series. And that's a little bit more complicated. But overall, no, you can't do that. You can't trademark a book title. Sometimes you can trademark a series. Again, that's more so if you're using it as a branding tool versus something else entirely. So don't get it confused in terms of, I wrote a book, I need to get a trademark. That's not how it goes. But if you have an overall brand, that gets a trademark instead. Things you should be considering getting a trademark are like the logos for your publishing house, if you choose to have one, or your LLC, if you choose to go that way, versus you need to copyright your books. So keep those two words separate in your mind and apply them the correct way. Copyright is for creative works. Trademarks are for brand identifiers. Now for this last legal term, I want to take a step back to really understand what I'm about to say. Just because something is online doesn't mean you're able to use it in your book. So say I find an image online that I think is really cool. I just can't throw that into my book because I may not have the right to it. Like we just talked about with copyright, that could be someone else's copyrighted work. I just can't take someone else's copyrighted materials and use them. Now I know what you're thinking. Well, how do I know if something is copyrighted and I have the right to use it? Well, copyright is automatically assumed for pieces of work. Even if you don't see that logo there, copyright is automatically assumed when someone creates something. And this is so important to keep in mind, again, going back to the legalese of everything. If you are using works from someone else and taking their works without their permission, they have the grounds to take legal actions against you, which means you taking down your book from whatever platform you're selling it on, possibly even getting sued for different things. So being mindful that just because you're finding things online doesn't mean you're able to actually use them in your book. Now, there is this thing called fair use, where essentially there is some wiggle room for you to be able to use things that are copyrighted within your book, but they have certain parameters that you have to fall underneath to make sure that that's something that you can actually do. And I'll throw them on the screen here now so that way you can see them. But these are wiggle room things that you have to know how to navigate correctly so that way you don't get in trouble for it on the back end. So think about things like Saturday Night Live. That is a comedy sketch show where they're doing a lot of parodies of different things, which is why they are able to mention things like maybe Disney or Mario Kart or the Barbie movie or Santa Claus, like all these different like big projects and these big IPs without getting in trouble, but they fall within this fair use category because they're doing it as a parody. And so if you're able to walk those lines, you're able to do that within your book. But if you're not, you could be subject to legal action. So just being mindful of that as you're developing your book idea and as you're pulling information, thinking about, are you allowed to do this? And if you are you doing it in the correct manner? A lot of people think like, okay, well, I'm going to change one or two things about this publicly known thing so that way people don't know what it's about. Or maybe I'll write a book about somebody really famous, but I just won't say their name. That still can get you in trouble. Just because you're not saying their name doesn't mean you're not taking advantage of their likeness or different things like that. So being mindful that even just changing one or two things about whatever you are borrowing from someone else can still get you in a lot of trouble. And I know what you're thinking. Is someone who's really big and famous going to know that I wrote a book about them? Maybe yes, maybe no. But it's in that gray area that leaves you open to having legal action taken against you. So even thinking about a book like this, More Than Peach, it's based off of a real young lady who did a lot of work to make sure that Crayola crayons were having colors that looked like different skin colors for people to color with. She wrote this book about herself, and she's allowed to because it's her own book. Whereas if I wanted to write a book about her and the work that she's done, I would have to get special permission to do so. And so being mindful about how you're taking information, even if you want to write a book about somebody famous, you can allude to them in your book or say like someone is inspired by the work that they've done. But the line there becomes when you're taking advantage and making money off of the work that they've done instead. When thinking about this in terms of can you use the likeness of a celebrity, for example, in your book, in terms of open knowledge, online information that you can put into your book, I think about the differences between Dear Martin and My Friend Martin. Now, beyond one being a book and one being a movie, right? But they both are talking about Martin Luther King Jr., but they're doing it in different ways, in different levels of intensity because of the permission that they have. So, for example, My Friend Martin is a movie from way back in the day, which is about a young boy learning about Martin Luther King Jr. But it's more intense, I say, because he actually is talking and interacting with Martin Luther King Jr. because there's time travel shenanigans and all that kind of stuff. And so, because Martin Luther King Jr. is not just an idea that he's thinking about in the cosmos and he's learning about in school, it's an actual person who is talking in the story and saying things. That director for that movie had to get permission from the King family to do that. And the King family gave him permission. They worked with the estate and all that good stuff. And that's why that movie is able to go more in depth and to have MLK be an actual character instead of just being something that the kid is thinking about. Now, you think about a book like Dear Martin, that book is more so like the beginning, like I was saying, of just a kid thinking about Martin Luther King Jr. and they're writing letters to Dr. King, but it's not like King has come back to life to read the letters and respond to the kid at any point. It's more so just an assignment at school for him to write letters to Dr. King. Both of those are talking about Dr. King, but they're doing it in different ways and different levels of intensity because one project had permission to go deeper and one project does not have permission to go in depth about Dr. King. But just being mindful that the internet allows you to have easy access to information, but access does not mean that you have permission. Now, to be an author, you don't need to be a legal expert, you don't need to be a lawyer, but you do need to be aware of some legal terms just so that way you can make sure that your book is protected and not going to get you in trouble once it hits the bookshelves. Now, if you've enjoyed what you've heard so far in this video, be sure to subscribe to The Author's Heartbeat so that way you don't miss an update as new videos drop on this page. Because this is the place that writers go to find clarity, confidence, and community. And we're so glad to have you here so that we can support you every step of the way.